Swayam Prabha. Digital India. Educated India.
Well, students, my name is Dr. Kumar Singh, Assistant Professor, Faculty of Law, BHU. So, this is my 35th lecture, which I am going to discuss before you. The topic of today's discussion is societal problems and human rights. So, in this lecture, I would like to highlight the problems which poor people are facing in this country and how those social problems are directly connected with human rights. So with the help of this slide, I would like to explain you firstly societal problems which poor people are facing and how these problems are directly connected with human rights issues. So I have chosen some important or sensitive issues which poor people are facing right now in this country. They have been facing, but I would like to throw some light on these important issues. The first is poverty, second is illiteracy, and third is unemployment. This is illiteracy, unemployment, population, child labor problem, violence against women, other social problems and human rights issues, violence against women. Bonded labor problem are also seen in many parts of this country, consumer rights, corruption. So these are certain areas where judiciary, particularly Supreme Court, has made a very good effort to rectify, to modify this, to ameliorate the plight of poor people. So let us understand this problem, how poverty, illiteracy and unemployment, child labor problems, bonded labor, these problems have affected the rights of poor people. You all might be knowing that right to life guaranteed under Article 21 of the Indian Constitution gives liberty to every person in this country to live with human dignity. And Article 14 of the Indian Constitution talks about equality. Every person is equal in eye of law. So, Article 23 of the Constitution, which prohibits bonded labor, Article 23. So, I would like to refer that provision, Article 23 and 24, which are directly connected with child labor problems. So, Article 23 says that states means no person shall be compelled to work against his wishes or desire. So here any person is compelled to render his services against his will or desire, it would be violation of his fundamental right provided in Article 23 of the Indian Constitution. So involuntary work without payment, where someone is compelled by an individual or state to do any work without payment against his desire, it would be a kind of beggar, forced labor. So forced labor and beggar both are prohibited by Article 23 of the Indian Constitution. So in order to prohibit forced labor and beggar, our constitution makers deliberately put these two important provisions, Article 23 and 24 in the Constitution. Article 23, which prohibits beggar, which prohibits forced labor, no one can be compelled to do any work against his wishes or desire. So this is the literal, the word beggar is not defined in Article 23, but literal meaning of beggar is involuntary work without payment. So where a person is compelled to do any work against his will without payment, without remuneration, it would be a kind of beggar. It would be a kind of forced labor, and it will be considered by the High Court or Supreme Court that right provided under Article 23 has been violated. So victim would be liberty to file a case under Article 226 in the High Court or under Article 32 of the Indian Constitution. On the other hand, Article 24 of the Indian Constitution talks about prohibition of child labor. Article 24 of the Indian Constitution says that no child below the age of 14 years shall be employed in any hazardous industry or in any establishment. So Article 24 specifically prohibits employment of any child who is below 14 years. No employer, whether employer is government or private employer, shall appoint a child who is below 14 years, because it would be a case of child labor, and the person who has employed that child who is below 14 years may also be prosecuted. Students, you might have idea about two important legislation. The first one is the Bonded Labor Abolition Act 1976. Parliament in the year of 1976, in order to prohibit bonded labor, a special act was enacted by Parliament in 1976. The name of legislation is the Bonded Labor (Prohibition Act 1976). So by that act, Parliament for the first time tried to prohibit bonded labor. You might have seen that in different parts of the country, laborers, workers are compelled to do work against their will, against their desire. Even they are not paid minimum wages fixed by the government. So employers, they are not providing minimum wages as per the mandate of minimum wages act 1948. You might have seen that in Uttar Pradesh, Bhadoi is a district where carpet industry is, where children are employed to engaged in making that carpet. In Faridabad district, which is situated in Haryana, so children are employed, or workers are forced to work in that stone quarries, just for stone cutter. They are working as a stone cutter. In state of Tamil Nadu, Sivkasi district, many workers, many children even are engaged in making matches. Or in Madhya Pradesh, in state of Madhya Pradesh, many poor people are involved in making bidis, kind of cigarette. So even private employers, they engage poor children. So because of poverty, since either children who do not have, either they are orphan or parents are unable to provide financial assistance, they are unable to send their children to the school due to money problem. So it has been seen that child labor and bonded labor, these two problems are rampant. In many part of this country, child labor and bonded labor are reported. Media has reported that there are certain non-governmental organizations like Badhua Mukti Morcha, that is run by Swami Agnivesh. So Badhua Mukti Morcha or MC Mehta, they have played important role in providing justice to the bonded labor, in providing justice to the child labor. So I will discuss those important cases one by one. But here the point is that it is the poverty. Because of poverty, people are involved. Poor people, they have to send their child or children in industry or and they don't send their child to the school, and so this is the main problem, and this is the problem. Poverty is main problem of child labor or bonded labor. The problem with bonded labor is that they are not in position to raise their voice. They are not aware about their rights. They are also poor. Many times it is seen that they are poor. So employers, greedy employers, they take disadvantage of their poverty and they engage in their illegal activities, in their illegal business. So Supreme Court has taken cognizance of all these things. I would like to highlight some important cases so that you can have. The first thing, you all might be knowing that there are three important things which are required for human being. That is roti, kapda or makan. That is food. That is shelter. That is livelihood. So these three things are very essential for the survival of human being. So without providing shelter, without providing guarantee of food, good or decent shelter, but people who do not have money, who do not have sufficient means to have a shelter, to have a roof, so rights would be meaningless for those people. So these three things are very essential for any democratic country, because India is a democratic country, India is a welfare state, and in the preamble of the constitution, our constitution maker, they have deliberately put this provision thus in order to ensure justice, social, economic and political justice to the citizen of this country. State shall endeavor to make. So this, you see, this social justice, economic justice and political justice cannot be achieved unless poor people are not provided education, unless poor people are not provided adequate or decent shelter, unless poor people are not provided livelihood. So all the fundamental rights and freedom for those poor people would be meaningless. So for that purpose, Parliament has enacted a special legislation in order to provide adequate food, in order to provide free and compulsory education to the children of poor people, in order to provide livelihood. Government of India and different state governments have welfare schemes regarding livelihood, regarding employment. Manrega is one of them. Mahatma Gandhi National Rural Employment Guarantee Act 2005. That act was enacted by Parliament in order to provide financial assistance to poor people of this country. You can see the first important component which I have chosen, that is food. So poor people who cannot manage meal for their children due to poverty, they are poor. So all the fundamental rights and freedoms would be meaningless for those poor people. As per government statistics, about 22% people are living below poverty line. If not 22%, if we say 15%, at least 15% people of this country are under below poverty line, meaning thereby they do not have sufficient means to manage their meal. So person having BPL card, they have access to different various government welfare schemes. They have access to different medical schemes. So the point which I am trying to justify is how food is essential for poor people. So I have highlighted one case, PUCL versus Union of India. You just can see this case on your screen. PUCL versus Union of India, AIR 2001 Supreme Court. This People Union for Civil Liberties took responsibility to file a petition before Supreme Court, and by that petition, the matter was brought into the notice of Supreme Court that in many parts of this country, like Kalahandi, Keonjhar and Mayurbhanj districts in Odisha, people died due to starvation. So government was unable to protect starvation death. Even media report revealed that few people died due to hunger, due to starvation. When starvation death was reported in newspaper and petition was filed by this NGO, Supreme Court took cognizance and Supreme Court issued direction to each and every state government. Chief Secretary of the state government was directed to ensure that no starvation deaths should be reported, should be occurred in any state. Because India is a welfare state, it is constitutional obligation of state to provide food to poor people, to prevent starvation death, to those people who are unable to, who do not have sufficient means to manage their meal. So this is the case where Supreme Court indirectly held that this right should be covered under Article 21 of the Indian Constitution, because without securing this right to food under Article 21 of the Indian Constitution, right to life or personal liberty or other freedoms would be meaningless. So this it is the responsibility of state government to ensure that poor people must be provided food. Because of that judicial intervention, Parliament has enacted Food Security Act. So Food Security Act is in the line of this judicial pronouncement, where different state governments will have to provide food to the poor people, and Government of India and several state governments have welfare schemes, and by that scheme they are providing food grains to poor people. So you might have seen this kind of welfare schemes which are being run by different states in this country. So food is important, and this way right to food has fundamental right. Now second important problem is illiteracy. Illiteracy and right to education. So how does literacy affect human rights? Primary education, education for all. You might have seen that there was a slogan that education for all. Every person, every human being, irrespective of caste, creed and religion, is entitled to get education. So in order to ensure education for all, you see, without educating people, without educating society, no country can achieve its basic objective. No country can become a developed country without educating its society, without having good rate of literacy. So India too has adopted this kind of scheme, and Parliament enacted a special legislation, Right to Education Act 2009. Before the enactment of that legislation, you might have seen that Supreme Court in 1992 held that right to education is a fundamental right. In Mohini Jain versus State of Karnataka, AIR 1993, Supreme Court held that right to education is a fundamental right under Article 21 of the Indian Constitution. No person shall be deprived from education. So right to primary education is a fundamental right. Earlier it was a part of directive principle of state policy, and state was under obligation to provide education free of cost to poor people, to the children of poor people. So Supreme Court recognized that right to primary education is a fundamental right, and because of that judicial pronouncement, Parliament enacted a special legislation in order to provide free education to poor people. Right to Education Act 2009. You may be aware about this special legislation which talks about that every child of this country shall have right to get education free of cost up to the age of 14 years. So every child who is above 6 and below 14 shall have right to get education. And a child who is poor, after producing BPL card, shall have right to get free education from the government. So this Right to Education Act 2009 is a big achievement for this country, where by this act free education is being provided to the children of poor people. So important thing is that two things which I have highlighted in this lecture: right to food, right to education. How illiteracy has affected human rights. People are illiterate. Because of illiteracy, people are ignorant about their rights, about welfare schemes. So unless they are educated, they do not have access to the welfare scheme of the government. So education is necessary. So for that purpose, Parliament decided to make a special legislation in the year of 2009, and as a result of that, Parliament enacted Right to Education Act 2009. Now come to another important or sensitive issue, that is child labor. How child labor has affected human rights? As I said, poverty is cause of child labor. So this case, MC Mehta has played important role in providing justice to the children of this country. Swami Agnivesh, he has also one NGO, that is Badhua Mukti Morcha. You can see on screen. I have chosen two important cases. First is MC Mehta versus Union of India, and second is Swami Agnivesh versus Swami Agnivesh. This is, and his NGO is Badhua Mukti Morcha versus Union of India. So I would like to discuss first case, MC Mehta versus, this is the case where MC Mehta versus State of Tamil Nadu. Discuss this case. AIR 90, MC Mehta case, AIR 1996, Supreme Court. So there is a typological error, so let me correct it. MC Mehta versus State of Tamil Nadu, AIR 1996, Supreme Court. So what happened in this case? MC Mehta was a social activist, he was a leading lawyer, and he filed a petition in Supreme Court by highlighting the plight of children who were working, child laborers who were working in Sivkasi district, who were involved in Sivkasi district situated in state of Tamil Nadu. So their children were involved, engaged in manufacturing of matchstick. So they were engaged in manufacturing of that hazardous manufacturing. On the other hand, Article 24 of the Indian Constitution, which prohibits to engage any child who is below 14 years in any hazardous industry or establishment. So no child below age of 14 years shall be employed in any hazardous industry or establishment. So MC Mehta filed a petition in Supreme Court by highlighting the plight of those children, and Supreme Court took the cognizance, and in that Supreme Court for the first time held that child labor is a social problem, is a big problem in this country, and Supreme Court directed the state government concerned that government should ensure that employer who had engaged children in their hazardous industry shall provide financial assistance to the children up to the age of 14 years. So they will have to, employer will have to provide financial assistance for their education. Employer will have to provide financial assistance to the families of the children. So for the first time, Supreme Court for the first time directed the state government to ensure that wherever this child labor problem was reported, that employer should be responsible for child labor problem, and that employer should be directed to create a corpus, to create a fund, child rehabilitation fund. So that child rehabilitation fund shall consist two important provision. 20,000 rupees shall be allocated for rehabilitation for his well-beings, and 25,000 rupees shall be deposited by employer for the education of that child to whom he had engaged in his hazardous industry. So child rehabilitation fund must be established, and in that child rehabilitation fund employer must be compelled to contribute in that child rehabilitation fund. So you see, this is the outcome of this MC Mehta case. Second important case is Badhua Mukti Morcha versus Union of India. What happened in this case? This is an NGO. Badhua Mukti Morcha is an NGO, as I said, which is run by Swami Agnivesh. A petition was filed in Supreme Court by highlighting the plight of children who were working in bonded labor. So this case is particularly related to bonded labor, and laborers who were engaged in Faridabad district in Haryana. So he highlighted that issue in the Supreme Court, and Supreme Court found that allegation true, and then Supreme Court directed the state government for the rehabilitation of bonded labor. Though when this case was decided, Parliament has already enacted the Bonded Labor Prohibition Act 1976, and by that statute, liability was imposed upon every employer, private employer, to ensure that there should not be no employer shall engage bonded labor in their establishment. So bonded labor is prohibited by the Constitution and by the statute also. In case of bonded labor, they shall also be prosecuted and convicted for offence. Bonded Labor Prohibition Act 1976. Considering the gravity of child labor problem, Parliament enacted Child Labor Abolition Act 1986. Because child labor was also a great concern, Parliament took it seriously and enacted Child Labor Abolition Act 1986. You might have some idea about that legislation. Now, come to another important sensitive issue which has also affected human rights of women. So violence against women, this is a great threat in protection of human right. There is a great two important threat: violence against children and violence against women. So these are two big threats in protection of human rights. So I have chosen this violence against women. So in this slide, I have covered three important provisions which you can see on your screen. The first one is Section 498A, statutory provisions, which talks about cruelty. Section 375, that is rape. Section 375 defines rape, and Section 354, that is immodesty against women. Equal Remuneration Act 1976 was enacted by Parliament in order to provide equal pay for equal work irrespective of sex. Women are also entitled to get equal constitutional protection for women. Article 14 and 15, Parliament has power to make. You see, there are several instances where violence against women has been reported in electronic media, print media. You might have seen, and most abusive provision of Indian Penal Code is Section 498, cruelty against women, dowry death. I have chosen only few important provisions so that I can explain you what is the problem, because it is not possible to cover each and every aspect in one lecture. So I have identified only few important statutory provisions of Indian Penal Code which are directly connected with violence against women. Cruelty is committed if mental or physical cruelty is committed by husband or relatives of husband against wife, then that is an offence offence under Section 498A of the Indian. And the nature of offence is cognizable, non-bailable, as per Schedule 1st of the Code of Criminal Procedure 1973. So just after lodging FIR under Section 498 cruelty, it gives liberty to the police officer to arrest that husband or relatives of the husband who have committed cruelty against that female. As per NCRB report, if I refer NCRB report, so you will be surprised to know that as per NCRB report 2012, NCRB report, I am referring NCRB report 2012, because this NCRB report 2012 is very important so far as Arnesh Kumar case is concerned. Arnesh Kumar versus State of Bihar, AIR 2014 Supreme Court. And in that NCRB report 2012 reveals that about 1,97,000 cases were reported under one section of Indian Penal Code. In the year of 2012, about 1,97,600 something cases were reported in one section under section 498A, that is cruelty. So you can see the sensitiveness of gravity of this crime, cruelty, which is committed against women by husband. This is the NCRB report 2012. In 1 year, the number of FIR registered in one section, that is about 1,97,000. So can you imagine that this violence against women, particularly in one section, the FIR was registered by victim of crime. When this matter was referred by a learned counsel in Arnesh Kumar case, and on the basis of NCRB report, cruelty and rate of conviction, charge sheet, the rate of charge sheet was 97%, conviction rate is 15%. Though I'm not going to into the technicality of that case, but here you need to understand that how this NCRB report 2012 reveals violence against women and particularly cruelty in one section. The number of FIR is 1,97,000. So what about other provisions like custodial rape or 375, outraging the modesty of women? You can imagine. So it has been a great concern of criminal justice system to have a tough law on this, and thanks to Parliament recently Parliament has enacted Bharatiya Nyaya Sanhita 2023, and in that act there is a severe punishment for such kind of offences. So this is all about your section 498 cruelty, 375, 354. In order to prevent violence against women, Parliament has power to make special legislation, and Parliament has enacted special legislation, that is the Protection of Women from Domestic Violence Act 2005. I have chosen this slide. You can see on your screen that gender injustice and human rights. Gender injustice and human rights. So Article 15 Clause 3 talks about a special provision where a state can make a special legislation for the